Il va sans dire que je remercie.
It goes without saying that I thank Professor Diego Fernandez Arroyo for having moderated this panel. We shall now immediately move on to the next panel. We're extremely late on schedule, and I think that nonetheless at 1 o'clock we will have to, in fact, take part in our lunch, our light lunch. So we'll move on to the next panel. I call on Professor Geneviève Bastid-Burdeau, Excellency Judge Georg Nolte, Excellency Judge Hilary Charlesworth, Professor Tullio Treves, Professor Makane, Moïse, Mbengue, and sorry for my pronunciation. I will hand over to Professor Geneviève Bastid-Burdeau to see whether or not, given the time, you will be able to hold a discussion, or maybe indeed whether we'll be able to hold that discussion during the light lunch. Thank you.
Well, first of all, I'm going to be very strict with the previous moderators. They didn't actually moderate enough, so I'm ticking them off. It means that we are left with a very short space of time to discuss some very important issues before the lunch break. And therefore, without further ado, I would like to give the floor to His Excellency. Just a moment. Yes, to the Rapporteur General, of course. So I give the floor to His Justice Georg Nolte. Your Excellency, Judge Nolte will be giving the overview. Thank you very much. Over to you. You have 10 minutes. 9 if you prefer.
I want to say that it is an honor for me to speak on the occasion of the 100th anniversary of the Academy. For those many students of international law who did not have the privilege of attending one of the courses, in my generation, we were seeing the hundreds of volumes of the collected courses, which had a profound effect on at least members of my generation and of the time that the gravitas of the time which the Academy worked. Now, the first two panels have focused on general aspects of our topic, substantive and procedural. The third panel is designed to move us to a methodological and more specific level. And we can ask, in short, should treaties which protect the public interest be interpreted differently than other treaties? This is not a new question, I think. Almost a century ago, in 1930, Arnold McNair famously suggested that we should, and I quote, free ourselves from the traditional notion that the instrument known as the treaty is governed by a single set of rules, however inadequate, and set ourselves to study the greatly differing legal character of the several kinds of treaties and to frame rules appropriate to the character of each kind. McNair thereby set off a debate whether lawmaking treaties should be governed by different rules of interpretation. One generation later, this debate was put to rest by the ILC. In its draft articles on the law of treaties, the Commission followed its Special Rapporteur, Sir Humphrey Waldock, who had written in his third report that, and I quote, "Some writers, in their exposition of the principles of treaty interpretation, distinguish between lawmaking and other treaties. It is true that the character of a treaty may affect the question whether the application of a particular principle, maxim, or method of interpretation is suitable in a particular case. But it is not thought necessary or appropriate," he said, "to distinguish between lawmaking and other treaties for the purpose of formulation the general rules of interpretation, quite apart from the difficulties in making that distinction." So, the rules of the Vienna Convention on the Law of Treaties, on the interpretation of the treaties, have been formulated with the question of general interests, or if you will, the public interest, in mind. But the real question is, of course, what that means and how it plays out. Broadly speaking, one can see two possible directions, and I apologize for all those who see an alternative between two as too simplistic. On the one hand, the rules on treaty interpretation can move us to look more closely at the specific public interest which any particular treaty aims to realize or to protect. On the other hand, it may also be possible to postulate an overarching public interest in international law which encompasses different sub-public interests and which should be taken into account when interpreting treaties. Let me make the following observation regarding these two possible directions. Treaties are, in the first place, treaties, that is, agreements between different parties. The individual parties are said to be masters of the treaty. Most treaties offer the parties with the possibility of terminating their obligations. The identification of the common intention of the parties is traditionally viewed as the most basic goal of any interpretation of a treaty. It is the parties who, according to Article 31, paragraph 4 of the Vienna Convention, determine any special meaning of the terms of a treaty. It is only intrinsic elements of the treaty itself which, according to Article 31, paragraph 2 of the Convention, can count as context for the purpose of interpretation. This includes the subsequent practice of the parties. And finally, it is the object and purpose of the treaty itself, not of international law more generally, which counts, according to this provision, for the purpose of interpretation. All these elements of interpretation favor the identification of treaty-specific and party-oriented public interests. There are, of course, also factors which may help to overcome such limitations. Certain terms or the object and purpose of the treaty itself may, in some cases, be interpreted as referring to matter which goes beyond any individual understanding by a party to the treaty. Such going beyond a party-centered perspective may also be justified by taking the relevant rules of international law applicable in the relation between the parties into account. I'm mentioning these basic methodological rules, which I'm a bit obsessed with, to explain why it is not surprising that the concept of public interest has so far not played a significant role when it comes to treaty interpretation. In fact, other terms that are mostly used to denote the interests which go beyond the individual interests of state parties. These other terms, which are more commonly used, are common interests, collective interests, and community interests. There is an important difference, particularly from the perspective of treaty interpretation, between the terms common, collective, or community interests on the one hand, and the concept of public interest. This difference consists in the fact that the terms common, collective, and community interests still somehow refer to individual actors and their interests. The term public interest, on the other hand, supersedes and even effaces any individual actors and their interests by invoking a public which appears to exist beyond a specific community of states parties. A public interest is not merely a common interest in the sense of an intersection or an accumulation of interests of individual state parties. No, public interest may go beyond and even be in contrast with individual interests. Public interest, the term, is a concept which originates from the theory and the practice of the state. The state represents in law typically the public interest vis-à-vis the individual interests of its citizens. This public interest may stand in contrast to the individual interest of the citizens. In that sense, public interest is a concept which stands in tension with the concept of a treaty and even transcends the concept of a treaty. The question is therefore how far the idea of public interest can play a role in the interpretation of treaties. Now, in my view, it is the wisdom of the Vienna Convention on the Law of Treaties, rules on interpretation, that they do not exclude the identification of an overarching public interest which is protected by a treaty, but they also caution against jumping to such a conclusion with a view of arriving at a preferred result, preferred politically or morally. These rules force the interpreter to carefully justify, by taking quite a number of means of interpretation into account, any conclusion that goes beyond the interests which the parties themselves have consciously and demonstratively adopted as their own. Now, I apologize for pouring this bit of voluntarist and perhaps formalist water into the public interest wine. But you perhaps excuse me if I mention that there are, of course, other sources of international law than treaties, which may give more room for public interest in the more substantive sense that I have tried to contrast with other interests. The contribution of our panelists will explore the significance of the concept of public interest in its different possible meanings for the interpretation of certain particularly important treaties or treaty regimes. And my understanding is that the organizers of the conference have carefully chosen treaty regimes, 3 treaty regimes or regime complexes for which an overarching concept of public interest plays a role in the process of treaty interpretation. Let me, in 3 short final remarks, I hope I'm still within my time limit. If I have a minute, that's exactly what I need. This role can play out in 3 different ways. First, by way of recognition. By concluding human rights treaties, states have recognized certain human rights as being so fundamental that they go even beyond the common or collective interests of the states which are parties to those treaties. Judge Charlesworth will address this aspect of our topic. Second, by way of construction. By establishing a regime like that of the law of the sea, states have constructed more than just a functional regime, but a public order here of the oceans. Judge Treves will speak about the public interest dimension of the interpretation of this regime. And third, by way of reception. By concluding investment treaties, be they bilateral or multilateral, states have created interfaces between international law and the classic public interest of any particular state. Investment treaties today not only serve to balance private rights of individuals and the traditional public interest of the state, but they also receive or give room to a certain broader-based interests of states. Professor Mbengue will deal with this aspect of the topic. Thank you very much for your attention.
Thank you, Your Excellency, for this very enlightening presentation. Cette présentation nous
This presentation was very helpful in terms of being more specific on the terms that we have used. I do apologize. Earlier on, I was in a bit of a rush, and I'm afraid I introduced you incorrectly. I do apologize for that, sir. Now, without further ado, I would like to give the floor to another Excellency, Her Excellency Judge Hilary Charlesworth.
Thank you, Professor Bastid-Burdeau. It's a pleasure to be here again, although I promise not to speak again at this conference. So I think the really rich discussion we've had this morning illustrates the elusive meaning of the term public interest, and that's been brought out again by my colleague Judge Nolte. Substantively, multiple conceptions of the public interest can coexist, of course, and potentially compete in any given case. It's typical for parties before the court to insist that their view of interpretation will promote the public interest. So I think the court's very used to having different interpretative methodologies put before them to vindicate different conceptions of the public interest. But it's much easier, I think, to distinguish public interest considerations if one focuses on the procedural level, particularly in terms of access to a forum such as the court, which gives parties the forum to discuss substantive conceptions of the public interest. So what I want to do is to show how the court's interpretive methodology has shaped the procedural safeguards that enable the protection and the vindication of the public interest in the context of human rights treaties or of provisions in treaties that deal with human rights. So what I want to do as a conceit for this is to offer a case study of the court's journey from the 1951 reservations to the Genocide Convention advisory opinion and bring it up to date with lots of leaps across the decades to the court's decision last year, which has already been referred to in two of the previous panels, the preliminary objections decision last year in the Gambia versus Myanmar. So I'll take 4 steps along the way. So I'll start with the advisory opinion in the Genocide Convention case. The question there, of course, was the permissibility of reservations under the law of treaties. And the case, of course, was delivered in 1951, and that the opinion was given in the very specific context of a procedural conundrum, which was a barrage of reservations made to the Genocide Convention's compromissory clause, Article 9, which granted jurisdiction to the court. So very famously, there's been a huge literature on this. If controversially, the court tried to steer a middle path between, on the one hand, universality of membership of treaties and the integrity of the treaty, and perhaps illustrating the maxim that the middle path is the only one that doesn't lead to Rome. That approach has been roundly criticised by many scholars as undermining human rights protection. However, of course, I think it's equally possible to understand the court's opinion there as an attempt to uphold public interest, if one takes a very constructive view of the judgment, by both recognising the role of reservations subject to the restraint of a treaty's object and purpose. So racing through the decades, the next stop on this journey comes, again, another equally famous case. Not least, perhaps, well, for Australians, it's a very famous case because I think it was decided on the casting vote of the one Australian president of the court, Sir Percy Spender, but the second phase of South West Africa. So what I want to do is to focus on the court's approach to the interpretation of the mandate for South West Africa. So on the question of standing, the question, as every student of international law knows, of Ethiopia and Liberia to challenge South Africa's performance of its duties under the mandate. The court set itself the task of ascertaining whether the applicants, and here are the court's words, possessed any individual legal right or interest. And taking that approach, that more or less eliminated from the start the prospects of legal standing for the fulfilment of obligations such as in the mandate that were not bilateral, not not bilateral or bilateralizable, if that's a word. Having scrutinised the mandate through a historical lens, what the court did was to insist that no legal interest could be recognised in favour of Ethiopia and Liberia, who were both former members of the League of Nations, unless those interests had been expressly stipulated in the mandate. And the court used the term, they said, the argument that the exclusion of such legal interests would preclude redress for violations of the mandate. They simply dismissed that and said that's an extra legal consideration. And again, this, I think, ties in with Judge Nolte's point. What's interesting is that the court said, well, what we're doing here is engaging in textual interpretation. But what's striking now, particularly with the benefit of hindsight, is that at some points in its judgment, the court simply refused to engage with or draw inferences from specific terms in the text. So, for example, the court denied, and again these are the court's words, that there was any residual juridical content to the reference in the League of Nations Covenant to the well-being and development of the peoples, the populations of the mandated territories as forming a sacred trust of civilization. And the court also stated that it considered that it was, again its words, highly unlikely that the drafters of the convention intended the compromissory clause to carry the broad scope that its terms arguably allowed. So the judgment had, of course, a very controversial aftermath. And it's often said in histories of the International Court that in articulating the concept of erga omnes 4 years later in Barcelona Traction, the court was trying to mitigate the repercussions of the Southwest Africa judgment in jurisdictional terms. So, on the other hand, again, coming through the decades, the third stop on the journey, the court in armed activities case, the DRC against Rwanda, found that reservations to the Genocide Convention and the Convention on the Elimination of Racial Discrimination were not incompatible with those treaties' object and purpose. Through that decision, the court effectively declined to expand its jurisdictional reach over potential cases of human rights and of clear public interest. So I think that underlines that for the court, the protection of the public interest always has to be considered alongside the court's institutional constraints, referred to by our president this morning, notably in this case the principle of consent, of consensual jurisdiction. At the same time, the court's jurisprudence shows that the protection of the public interest requires that where such jurisdiction is affirmed, it has to be exercised to its full extent. And that proposition is illustrated by the last stop on the journey, the pending case of the Gambia against Myanmar. When Myanmar objected to the Gambia standing to bring a case against it under the Genocide Convention, unlike in Southwest Africa, the court's inquiry into the Gambia standing didn't directly revolve around any special interest that the applicant had to demonstrate. Instead, the question for the court was the legal relationship between the parties to the convention, which, in the court's view, flowed directly from the convention's object and purpose. So in Southwest Africa, the court had insisted that the interest in carrying out the sacred trust of civilization lacked juridical expression. But in the Gambia versus Myanmar preliminary objections case, the fact that the parties to the convention had a common interest in compliance with its obligations, that was the link that sufficed to provide all parties with legal standing. In addition, the court attached weight to the argument that there would be no legal redress against alleged violations of the convention if some extra special interest were necessary, precisely the argument that had been dispatched very quickly and considered extra legal in the Southwest Africa cases. So I think if one reads the judgment of last year, one can see perhaps an implicit dialogue with the Southwest Africa judgment, and the court effectively in the Gambia versus Myanmar effectively held that any restrictions on standing rather than any expansions on standing had to be made explicit in the convention. So So the court effectively held that the standard and rather modest compromissory clause in Article 9 of the Convention allowed the Gambia to invoke Myanmar's alleged responsibility in the merits phase. So to conclude then, the journey that I've just, it's a whistle-stop tour through the court's jurisprudence and highly selective too. This journey from reservations 1951 to the Gambia versus Myanmar 2022 suggests that the court's approach to treaty interpretation has developed in the direction of simplifying the articulation of human rights grievances, arguably promoting the public interest. And I think that development can be understood as a product of a dialogue over the decades between the court, states, and civil society. So I was struck by Professor Wolfram's regret that he expressed this morning that there was no specific reference in the preliminary objections judgment to Article 48 of the Articles on State Responsibility, endorsing the notion of erga omnes obligations. But we can see that, I think, the court's reasoning in the Gambia versus Myanmar preliminary objections is clearly influenced, deeply influenced by the principles of the invocation of responsibility in the public interest, or in the court's terms, common interest, that were expounded by the International Law Commission and, of course, systematised by James Crawford as its special rapporteur. Both parties in their arguments referred certainly to that work, and one sees that implicitly in the court's decision. And of course, those principles, the International Law Commission's work, were in turn inspired by the seeds sown by the court in the Barcelona traction case, and also by extensive practice. So this jurisprudential conversation, if I can call it as such, between states, the court, and in this case the International Law Commission, illustrates that the development of legal principles that defend and advance the public interest is a collective enterprise, and that itself surely is a matter of public interest.
Merci beaucoup.
Thank you very much indeed, Your Excellency. Thank you for talking us through this trajectory, with reference, of course, to the case law of the International Court of Justice. And we shall move on now to the area of interest of Professor Tullio Treves, who is a great master in this domain, public interest, and of course within the general context of the law of the sea.
Madame la Présidente,
Madam Chair, Excellencies,
and friends, it is with some emotion that I come back to this podium for this brief intervention. The United Nations Convention on the Law of the Sea, the UNCLOS, is a treaty, is an international treaty, and must be interpreted following the rules of international law concerning the interpretation of treaties, namely those rules that are largely incorporated in the Vienna Convention on the Law of Treaties. Public interest concerns are not directly mentioned in the rules on treaty interpretation in the Vienna Convention. They may, however, be relevant in determining, under Article 31(1), the object and purpose of the Convention. A brief indication of the object and purpose of the UNCLOS may be seen in the goals mentioned in the following paragraph of the preamble. The term goals belongs to the following paragraph. Recognizing the desirability of establishing through this convention, with due regard to the sovereignty of all states, a legal order of the seas and oceans which will facilitate international communication and will promote the peaceful uses of the seas and ocean, the equitable and efficient utilization of their resources, the conservation of their living resources, and the study, protection and preservation of the marine environment. Here in one paragraph you have not all but most of the goals and so the object and purpose of this very important 320 articles long convention. The general interest of all states, in my view, is addressed by the convention just through the provisions implementing the goals that are set out in the paragraph I mentioned above. The convention does not include rules explicitly addressing its interpretation. However, the above quoted provision of the preamble, stating that the legal order of the seas must be established with due regard to the sovereignty of all states, followed by various provisions of the convention referring to due regard, may be useful in interpreting certain provisions. And of course, I could make many examples. I would concentrate on this idea of due regard as a key to look at the complex structure of the UNCLOS. Due regard, as well as the sometimes used and equivalent term reasonable regard, is the notion through which the Convention addresses the situation of potential conflict between equally licit activities in the seas. So, under Article 87, freedoms of the high seas must be exercised, and I quote, with due regard to the right of other states in the exercise of the freedom of the high seas. The freedoms of the high seas that under the Convention apply to the exclusive economic zone must be exercised with due regard to the rights and duties of the coastal state. According to Article 58.4, while the coastal state's rights in the exclusive economic zone must be exercised with due regard to the rights and duties of other states. There are several due regard provisions in the Convention. It would be too long to list them all. Two examples may be added to the mention made above of Article 87 on the high seas and of Article 56 and 58 on the exclusive economic zone. Under Article 79, paragraph 4, states exercising the right to lay cables and pipelines on the continental shelf shall have due regard to cables or pipelines already in position. Another example is Article 234, stating that the law and regulations concerning pollution from vessels in ice-covered areas within the exclusive economic zone, and I quote, shall have due regard to navigation and the protection and preservation of the marine environment based on the best available scientific evidence, end of quote. Another and last example is Article 147, concerning accommodation, and I'm quoting, of activities in the area and in the marine environment, while paragraph 1 states that the activities in the area, which mean exploration and exploitation of mineral resources, shall be carried out with reasonable regard for other activities in the marine environment. Paragraph 3 states that other activities in the marine environment shall be conducted with reasonable regard for activities in the area. The obligation of due regard is set out as reciprocal in key provisions of the Convention. Clearly, for instance, in Article 87, paragraph 2, as regards the exercise of states of freedom of the high seas in relation to the exercise by other states of these freedoms. Under Article 147, activities in the area shall be carried out with reasonable regard for other activities, and other activities shall be carried out with reasonable regard to activities in the area. Not all the provisions concerning competition between equally legitimate activities and containing a due regard obligations are, however, couched in reciprocal terms. Still, it may be some of the provisions that are not couched in reciprocal terms, in my view, may be interpreted as being reciprocal. Due regard has been correctly, I think, defined by the International Tribunal for the Law of the Sea in the Bangladesh-Myanmar judgment as a principle reflected in various articles of the Convention and consequently applicable to the so-called grey areas, the areas that are spaces whose regime is not covered by the Law of the Sea Convention. Professor Oxman has accepted this view, stating that who was an ad hoc judge in that particular case, has accepted this view, stating that the specific provisions in the Convention are manifestations of a more general organizing principle of due regard in the law of the sea. As recalled above, the Bay of Bengal judgment of the UNCLOS sees the obligation of due regard as a principle reflected in the Law of the Sea Convention provisions utilizing it. But what is the legal nature of such a principle? One could argue that the extension to situations not envisaged by the rules of the Convention providing for due regard is affected by way of analogy, so that there would be a treaty basis for such an extension. However, one could also argue that the existing rule of due regard reflects a broader customary law rule necessarily implied in the existing rule of due regard and the need to ensure coexistence between the customary freedoms of the high seas, the rights in the area and the rights of the coastal state in the economic zone and on the continental shelf. This organizing principle that I would hesitate to call customary may be seen also, in my view, as an interpretive principle. In other words, a principle that applies to the interpretation of the Convention in all cases in which there are equally legitimate activities in an area of the sea. The interpretive nature, or at least the possibility of using it for interpretive purpose of the due regard principle, permits to apply it in all cases in which there is competition between equally illicit activities in an area of the sea, even when due regard is not explicitly mentioned in the Convention. So, to refer to an example made above, navigation and other freedoms of the high seas must be exercised with due regard to the rights of the coastal state on the continental shelf, even though the Convention mentions only due regard for navigation in the exercise of the coastal state's rights on the continental shelf. It has been stated that due regard is a procedural principle, because its application requires consultations aiming at obtaining a balance of rights and interests, to use the language in the Chagos arbitral award, not necessarily involved that one activity is granted a priority, as clearly stated in the same award. It can be agreed that due regard is a procedural principle because it requires that the states involved in competing activities engage in a process of consultations that must be timely and include reciprocal communication of the relevant communication. Also, this is stated in the Chagos Award. It is not, however, merely a procedural principle. It aims at obtaining a substantive result, namely, to use the terminology of the title of Article 147, to ensure the accommodation of competing activities. It requires that states engaged in these activities exercise restraint and consideration of the other state's interests. This principle serves to avoid or to eliminate conflicts. Consequently, it serves the public interest. Thank you very much.
Merci beaucoup pour cette...
Thank you very much indeed. Thank you for talking us through this major convention on the rights of the law of the sea. And now we've moved to our final subject for this panel, which is on investments, and we're going to listen to Professor Mbengue.
Between the audience and lunch, I'm sorry for that. So it may sound to many to hear about public interest in the interpretation of investment treaties. Indeed, when you look at the vast constellation of investment treaties, in particular bilateral investment treaties, there is almost no room for public interest. The traditional dominant model of investment treaties has been focusing on investment protection. And when you look at those investment treaties, what you can see is that the foreign investor is the spoiled child of the international law family. I think that in every family there's always a spoiled child, even if the parents do not want to admit it. And in the international law family, the spoiled child is the investment treaty. Why the foreign investor, sorry. Why am I saying that? It's because investment treaties mainly contain rights for foreign investors. Right to non-discrimination, right to fair and equitable treatment, right to full protection and security, right to compensation, right to automatic access to arbitration, rights. States, on their side, are only subject to obligations. So what does it mean? It means that in reality, in the context of investment treaties, you have an asymmetry between the rights that are given to investors and obligations that are imposed on states. And this asymmetry means asymmetry between private interest and public interest. And it is because of that asymmetry that investment tribunals, in their vast majority, have been quite reluctant to integrate or to take into account public interest in the interpretation of investment treaties that are submitted to them in the context of investment disputes. There's always one example that I like to give, Madame la Présidente, which is a case a few years ago, Von Pezzold versus Zimbabwe, where the tribunal had to deal with rights of indigenous peoples, cultural rights, rights to water. And in one of its decisions, the tribunal said that it doesn't really understand or it doesn't really see what is the relationship between human rights law and international investment law. The tribunal was not able to see. And and its conclusion was to say that an investment tribunal is not supposed to take into account, I quote, the universe of international law. So this exclusion by this tribunal of the universe of international law is de facto an exclusion of the universe of public interest that are regulated and protected under international law. So investment tribunals are not vectors of systemic integration of public interest. They are, in my view, more vectors of limitation of public interest. And again, this may be justified or explained by the asymmetry that is inherent to investment treaties. And so what we are witnessing today is a sort of general consensus from the community of nations that the fate of the interpretation of public interest should not be left to investment tribunals. And so governments today are negotiating a new generation of investment treaties that are really attempting at bringing more predictability on how investment tribunals or any dispute settlement mechanisms under those treaties would deal with issues of public interest. And when we look at the practice and when we look at this new generation of investment treaties, we can identify four main legal strategies or four main legal approaches to actually bring more predictability in the integration of public interest when interpreting investment treaties. The first legal strategy is what I would call formulating public interest as a right. More and more investment treaties affirm or reaffirm the right to regulate of states, the right to regulate in order to pursue public legitimate objectives such as the protection of the environment, the protection of health, the protection of labor rights, etc. So this is one legal strategy that is there. A second one that we can identify is what I would call shaping public interest as an obligation. We are now witnessing the emergence of a new generation of investment treaties where investor obligations are incorporated. This is very novel, this is very innovative, incorporating investor obligations, obligations to protect the environment, obligation to protect human rights, obligation to not to emit greenhouse gases, obligation to combat corruption, etc. So a set of obligations that would guarantee that when investment tribunals interpret those treaties, they would try to bring more balance between the rights that are given to investors, but also the obligations that they are supposed to comply with. Third legal strategy, what I would call upgrading public interest as an exception or as a carve-out. So some colleagues here might say this is maybe downgrading if you talk about exceptions or carves-out. But when you know that traditional investment treaties have been containing very broad and even sometimes a rather absolute provision, standards of investment protection, you understand that inserting exceptions or carve-outs is actually a way to guarantee more integration or more taking into account of public interest. And then fourth, last but not least, fourth legal strategy, the proceduralization of public interest. We are seeing now a new generation of investment treaties that are proceduralizing public interest. Taking into account public interest is not just an issue of substantive rights in the context of investment law, it is also an issue of procedural rights. How do we make sure that states can defend their right to defend public interest? So counterclaims, for instance, recognizing the right to states to file counterclaims in the context of investment disputes. Now, if you push the reasoning even further, now you even have proposals on the table saying, oh, one way from a procedural point of view to preserve public interest is to put an end to investment arbitration. And the European Union, for instance, is proposing to create a multilateral permanent investment court. And that multilateral permanent investment court is supposed to be more compatible with public interest than using ad hoc investment arbitration. So, Madame la Présidente, just to conclude, I think that there is this shift today, there is this shift that is showing that states are more and more concerned about the need to incorporate public interest issues in investment treaties, and I think that in a context of sustainable development, it's a very good move. Now, the question we need to ask ourselves is how far this idea of public interest should be taken into account. I'm raising this question because recently in Africa we've been facing a rather peculiar situation. So last year in 2022, an investment protocol was negotiated, the investment protocol of the African Union, which is supposed to apply across the African continent. And when crafting the provision on expropriation, we used the usual criteria and the customary international law that expropriation can happen if it is for a public purpose. In February, at the moment of the adoption of the investment protocol by the head of states of the African Union, one country, I'm not going to say which one, but it's a powerful one in Africa, one country decided that no, the protocol could not be adopted because the provision on expropriation just refers to public purpose and not to public interest. That country wants the word public interest, not public purpose. And so it was going to create a lot of problems, and at the end there was an agreement to adopt the protocol, but to reopen the negotiation of that provision. I don't know how you adopt a treaty and then you reopen negotiation, but they reopened negotiation on that provision to make sure that public interest would be there. So we see that maybe we're going sometimes a bit too far with how to integrate public interest. I think that the importance of public interest, for instance, should not put aside some of the customary criteria that we are used to see in investment treaties, and the idea of public purpose can encompass the idea of public interest. But then I've been always wondering whether this country had a crystal ball and knew what the court would say in its judgment in certain Iranian assets, where the court said that legitimate public welfare was always contained in the notion of expropriation. So I don't know if that country knew what the court would say and say, I want public interest and not public purpose. I doubt, of course, but it's very interesting to see that. But I will just finish by saying that let's not replace one asymmetry by another. Public interest is important, but when it comes to investment, in particular for developing countries, it's important to guarantee balance between public interest but also private interest, and I don't think that we should replace one asymmetry by another one. Thank you very much for your attention.
Merci beaucoup pour...
Thank you very much indeed for that presentation. It goes to show that public interest is still very much up for discussion in this area, and I would like to thank you in particular for your final words. I turn now to the Secretary-General of the Academy. Could we possibly entertain one question, or do we break for lunch now? Well, obviously, I need to turn to the President of the International Court of Justice and ask for her guidance on this. Would you possibly authorize another 10 minutes or so? Would that be all right? Yes. Oh, thank you so much. Thank you. Very well, says Mrs. Bastide. So we have the blessing. We have the blessing from the highest possible instance. Thank you very much. And therefore, I would like to call for questions. The President herself has a question, I understand.
Or partly to spare the last speaker from being the person who prevents the rest of us from having lunch. I'll take the blame instead. But also because there's a question that's been bothering me all morning, and I think the answer might be more obvious than it is to me, so I'll ask it. And the question is, what does public interest mean? And I ask this inspired partly by the last speaker's comments, because there the observation was made that this not named country saw a distinction between a public interest and a public purpose, which seems understandable to me. But then I noticed in many of the presentations today that what was described as a public interest by speakers to me sounded more like a common interest among various states. And so coming to the meeting this morning, I was thinking that public interest had something more to do not with the interests of states qua states, whether there's one or two or many, but rather with the interest of the public, which is theoretically protected by states, but is different and can be expressed in certain settings in different ways. So it's a curiosity for me that was on my mind all morning, so I thought I'd take the opportunity to ask, and I thank you. And I apologize for delaying lunch.
Merci.
Thank you very much, Your Excellency. Another question over here, perhaps?
Bonjour.
Yes, good afternoon. Raphaël Morin, University of Burgundy, Bourgogne. I have a question that I would like to put to the panel, and it concerns the fourth strategy that you just spoke about, in fact, the European Union strategy. What do you think about that possible development? What is your opinion on this? Do you think it goes in the direction of public interest? And if so, what public interest? That's the gist of my question. I look forward to your reply.
Alors nous pouvons...
Professor Bastid-Burdeau, well, let us see. Maybe, oh, sorry, there's another question over here. I do apologize. A further question from the floor.
Carlo De Stefano, Roma Tre University. I also have a question for Professor Makane. What do you think is more relevant in this problem of enforcement of public interest in investor-state dispute resolution? So is it more a substantive or procedural problem? And how is the discussion on selection of adjudicators important in this respect, especially including the discussion on the right of the investor to have the choice of at least one adjudicator? Thank you very much.
Well, I think most of the questions were addressed to you, sir. Mr. Mbengue. Thank you very much, Madam Chair.
A question about whether public interest is common interest or something that is more limited to the interest of the public. In the context of international investment law, public interest sometimes refer to the interest of the public, and we've been seeing investment tribunals actually talking about the interest of the public, but most of the time when they were dealing with procedural aspects. So for instance, when certain non-governmental organizations wanted to submit amicus curiae memorials, some investment tribunals have looked at public interest like the interest of the public, and in the name of the interest of the public, we should allow non-disputing parties, such as NGOs, for instance, to have the right to intervene in investment proceedings. And I think that this idea of the public interest as the interest of the public has even led to the amendment of certain procedural rules, like the exit rules, and even led to the adoption of new generation of procedural treaties, like the Mauritius Convention on Transparency. I think those are really there for the interest of the public. But then when it comes to substantive rights, in my view, most of the tribunals, when dealing with public interests, look at public interest as the legitimate public policy objectives of a state. So the policy objectives in terms of environmental protection, in terms of health protection, labor protection. So it's more oriented towards what are the legitimate public policy objectives of a state than the interest of the public. Raphaël, en relation avec ta question pour laquelle je...
Raphael, in answer to your question, and I thank you for your question, I've always thought that we were putting the cart before the horse here. What I mean by that is that right now there are states who will argue that in order to resolve the problem of public interest in investment litigation and the interpretation of investment treaties, they say, why don't we create a new court, a multilateral investment court? They think that that will solve the problem. I happen to disagree. I disagree, because it seems to me that investment arbitration tribunals may not have much power when it comes to the interpretation of investment treaties, but the investment treaties themselves, let's face it, did not actually mention the question of public interest. It's not mentioned in there. So you can, of course, interpret with some elasticity and introduce into the treaty something that wasn't originally in there, but I think it's understandable. I mean, these tribunals are there to enforce a treaty reached by sovereign states. Why would they go beyond that? Why would they actually exceed what's said in the treaty, or the content of the treaty? So I'm afraid I don't agree. And in a way, that brings me to Carlos's question.
How do I see the dialectics between substance and procedure? And I think we should not separate them. I think we should not separate them. The reform of the investment regime, to foster sustainable investment has to be both substantive and procedural. If we just reform treaties without reforming the procedure, so reforming, for instance, investment arbitration, it won't work. But if you also just limit yourself, as UNCITRAL is doing right now, UNCITRAL Working Group 3, at discussing only procedure, it won't fix the issue in the system. So I believe that we need to have a systemic, a more holistic perspective. How do we reform both substance and procedure? But maybe we need also to think a bit outside the box. You know, maybe today we need to think about new type of mechanisms, using more alternative means of dispute resolution. I know that in Africa right now they're discussing about creating a compliance mechanism when it comes to investment disputes. So like in environmental treaties where NGOs, investors, states would have the possibility to raise issues of compliance, and the compliance mechanism would just facilitate the implementation of a treaty. So we are moving beyond the confrontational perspective, and maybe to guarantee public interest, we need to move beyond that confrontational perspective. I'll stop there, Madame la Présidente.
Merci beaucoup. Je crois que...
Thank you very much indeed. Judge Nolte, Your Excellency, I think you have some comments as well in response to the questions.
Yes, thank you very much. I wanted to share with you that I had the same question or concern as President Tullio when I was asked to prepare a statement on introductory statement for this panel, because I was asking myself, here we have a familiarly sounding concept which we use in a context which we have not so far used it very much, at least. And this is a very representative event. So many international lawyers will say, oh, there's public interest in international law. And I expected, and I felt confirmed by my expectation that a number of speakers would use the term public interest interchangeably with common interest. And so that we would, by this conference, in a sense, produce a new paradigm in international law, which would contain perhaps unspoken assumptions, because it sounds so similar to what we are used to. And I wanted to, by my presentation, a bit caution against this, this temptation. The topic of treaty interpretation is more conducive to expressing caution, because when you don't have the term, you cannot so easily project it into the system as if you speak about the system generally and then you assume. But I think one needs to be very cautious and particular. For example, this distinction between public interest and public purpose. For the purpose of treaty interpretation, there may be a world of a difference. It is very easy for a reviewer to ask whether a particular measure pursues a public purpose. One can say it may be good or may be bad, but it's clearly a public purpose. But the question whether it pursues the public interest, and to ask a court to determine that public interest without specification, that's another matter. So my sense is that public interest is a term which comes from national law, which presupposes the state, and which presupposes also the competence to articulate, to specify the common interest, which is a function which is more difficult to achieve in international law. For us, in this particular moment in history, it is a term which we immediately come up with because we are thinking of public interest litigation. We have these cases and we feel we are in search of a word for this tendency of our time. But the question is whether this concept of public interest litigation should be, let's say, put onto international law more generally, and I think we need to think about that. Thank you.
Je vous remercie.
Thank you very much indeed. That's an excellent conclusion. I really truly think so. A good end to the morning, and it's given us plenty of food for thought to think more about this concept of the public interest. And it's true, it doesn't have the same meaning, if you like, in the international order as it does in the domestic one. Thank you.
Un grand merci.
Thank you very much indeed. Thank you, Professor Bastid-Burdeau. Thank you very much also to the panelists, Your Excellencies, professors. Thank you very much indeed. Time has come for our lunch break. We're running a little bit late. I don't think it's disastrous. It could actually be worse. Could be worse. Our guests are very disciplined, so thanks to them, we're doing not too badly. But I do think we should nevertheless shorten our lunch break a little tiny bit, where there aren't quite as many of us here as we originally expected. So can we come back to this room at 2:15, please? 2:15. Thank you very much. See you at 2:15. Bon appétit.